So I'd asked everybody to send me, but not everybody did. So I've got information on some than others. That's the problem. It's okay. It's fine.
My authority is lower and lower.
Yes, I understand. Well, then I'll just get us going. We don't want to be between you guys and lunch. And so we want to get this going. And what's exciting about this panel, for me at least, is we've got a group of emerging scholars here who I want to learn from today, but I expect to learn from in the future. So I think this is really exciting. And everybody, it's a large group. It's only going to have 5 minutes. I don't want to take too much time. And as I said to them, I don't really have much information more than what's on the in the program for the introductions. So they will just give their name and start, and we will go like that. So first of all was Jihyeon. Go right ahead.
Hi, I'm Jihyeon. I'm from University of Washington in Seattle. I'm going to start off talking about international laws that are written by dictators, which I like to call authoritarian international law. International law isn't exclusively reserved for liberal democracies, and a growing number of dictators are writing and drafting their own international law, multilateral treaties in my context, and they're using it for various purposes. So the very first question that should be addressed from the get-go is there any difference between international law by autocrats and democracies, right? Because they might end up being the same. And I argue, yes, they are very different in two ways. First, authoritarian international law reinterpret existing legal principles in very different manner. So there's an existing notorious example of Shanghai Cooperation Organization Charter designed by China and some other countries in South Asia. And the charter explicitly mentions when there is a conflict between humanitarian goals and domestic political goals, the latter should always prevail. So their law allows, and to some extent mandates their members to prioritize their domestic goals, whatever that be, over other goals like human rights issues, etc. And the debate between the responsibility to protect and sovereignty isn't new at all, right? Debate was indeed triggered by liberal democracies. But the thing is that debate was left unconcluded, and autocracies have picked up where all the liberal democracies have left off. So the debate has been going on among autocrats, and they're somehow emphasizing the principle of sovereignty over others. And the second way in which these two differ is based on when and how states invoke their own regional treaties. And without much surprise, autocracies are invoking their own laws in circumstances that are very different from how liberal democracies have conventionally used their own treaties. Cambodia has recently disbanded the main opposition party, and the leader of the main opposition party has fled to the Philippines to seek for asylum as a political refugee. And unsurprisingly, the Philippines has rejected their request. And what makes this case so interesting is that they invoked their own regional treaty, the Association of Southeast Asian Nations Charter, and they mentioned, according to our law, we have principle of non-interference, and hence we're simply abiding by our law. So these laws are being invoked in somewhat different ways, and it has huge human rights ramifications, let alone political ones, right? So understanding what this is and how we make of it, and to what extent we grant legal authority and legal standing is significant. Against all these backgrounds, my research question asks, well, international laws can shape public opinions, it can shape public preferences around certain foreign policies. And I ask, well, what if those laws were written by dictators? What do people think about these international laws by autocracies when they themselves are not considered illegitimate, right? So in my survey experiment, I asked people how they think about international law by dictators and what their opinions are when dictators are invoking somewhat illiberal principles that's still enshrined in the form of multilateral treaties. And I'll stop there.
Thank you. Bianca del Bôas.
Yes, that's good. And I will try to stick to the time. And you guys must have noticed that we are in blacks. Right? We are kind of mourning for the autocratic trends right now. And I'll give a glance about Brazil and the role of the Supreme Court. So just briefly, because just briefly because many of us have heard during the exchanges that Brazil underwent an anti-democratic government during 2019 till last year. So just to give a brief context, that was not merely due to autocratic legalism or just abusive constitutionalism, but what Rubens Gleiser, Ana Lara Barbosa, and Oscar Villena from FGB had named infralegalism, authoritarian infralegalism. So in this context, STF, which is the Supreme Court of Brazil, has been hailed as an important or maybe the great savior of Brazilian democracy, because it was able to control those acts that Bolsonaro's government was enacting. And then some scholars, not just from Brazil, but from worldwide, started to framing STF by this example of what a practice in militant democracy should be, or maybe in material sense could be in a realistic way. So my main point here is maybe to question that, because indeed that is true, but it's not the whole narrative. And then for that, we need to consider that by this same study that I already mentioned, there's evidence that shows that STF only started to control Bolsonaro's government acts by 2020. And what happened and what transpired during this gap, well, we all know, and the epidemic was there, but we have some data that is worthy mentioned. Also, that is about the popularity of Bolsonaro's government and the STF. So in 2019, at the outset of Bolsonaro's government and at the peak of his popularity phase, 38% of Brazilians, according to La Pop, agreed to the notion that the STF could be shut down. And that may be a minority, but this figure more than doubled in less than a decade. So the STF in that moment was not at its best. On the contrary, it was much of its worst. So in that same year, various anti-democratic measures from Bolsonaro government concerning indigenous lands, firearms, and bodies controlling and preventing torture were taken to court and contested, but STF did not judge anything. Or even when it was judging and taking those trials into consideration, it was enacting declarations of unconstitutionality by only procedural reasons. So if the tribunal was very timid at the time. So I will just skip, and I hope we can back to the points I will skip now in Q&A, but there was a very close relationship, especially between the president of the court and Bolsonaro's government during that first year. And what we have to take into consideration to question this notion about the STF being the savior of Brazilian democracy is that it only started to control in Bolsonaro's acts after the popularity of the government dropped. So we need to question, to scrutinize on that. Even though constitutional courts take strategic actions for political survival, we also need to question and take into consideration that how much truly resistant is a court that only feels comfortable to act when the tide starts shifting against the autocrat. So that is a point I wanted to bring, because we need to acknowledge what the Supreme Court of Brazil did, but we need also to highlight the opportunities that were missed, and also what the court did not do, and maybe that this not doing was one of the main reasons that allowed the regression, the democratic regression, to gain momentum. And I'll stop here and hope we can discuss more in the Q&A. Thank you.
Thank you. Julia Goldani.
Can I just speak from here? Yeah, that's fine. Well, yeah. Hi, everyone. Like a lot of people here, I'm from FGV São Paulo. And as I've had maybe the chance to comment with most of you, my topic of research is the police in Brazil, and most specifically the military police. So just a brief context, these are the military polices of Brazil were institutions designed in the way that they are today during the 1964 dictatorship, and that were not fundamentally altered during the transition to democracy. So a lot of scholarship has focused on why that we kept them when transitioning to democracy, but the debate has been growing on why we didn't do it after also, because it's been 30 years and okay, maybe we didn't reform the police, but we did reform a lot of things that should allow us to change what is not going well, especially since police violence levels have been at a constant high since freedom of regulation. So a little bit different from my colleagues, I think my topic is not really the current wave of autocratization, but really how public security in Brazil has been constantly re-autocratized in a time of normal democratic standards. And for this, I've been developing case studies on reform attempts. And so what I chose to do with my time today is just sharing my current main finding in one of the case studies with you. This was a case study on a bill proposed in 2013 after the mass protest cycle we had, and which proposed a comprehensive structural reform of the military polices, including but not limited to the militarization. And the main finding was that this reform was politically abandoned, essentially because it generated conflict between different police corporations. And I'll explain why this is relevant. So Brazil has several different types of police forces, and most of these have like strong internal divisions between low and high ranking officers. So police chiefs or non-commissioned or commissioned officers in the military case, and just normal policemen. And although the police is not allowed to unionize in Brazil, most of these police categories, they created associations in the wake of the 1988 Constitution, officially meant for leisure, but that became strong lobbying bodies in Brazil. And each association, especially those that are hiring, have become strong stakeholders, and they all have different leverage over the political power in Brazil. So for instance, the federal Brazilian police, which is the civilian force, is very well connected to the Ministry of Justice, and they're also responsible for corruption investigations. On the other hand, the military police forces constantly make veiled threats of public order disruption, in the sense that if they lost control of all the police contingents of these millions of armed men, it would be chaos. So there's this constant battle of informal vetoes. And of course, because these corporations are institutionally and legally very distinct, they have different interests regarding the form of the police and the interaction between them, who gets to investigate, who gets to patrol. And that makes it so that any measure fundamentally will make some of these corporations happy and some of them very angry. And because they all have this informal vetoing power with very important issues, so corruption or public order, all very sensitive topics, there's two main effects. The first is that any legislative debate comes to a lobbying deadlock, because they all control relevant commissions and relevant congressmen. And the other is that there are very strong incentives for the presidency, which in Brazil's system is the actor with most political capital that can maybe undo a lobbying deadlock. There are very strong incentives for the presidency to remain absolutely neutral, because any stance that is taken will make one police force unhappy, and that can lead to some sort of, you would basically be taking your pick from a set of high political risks. So what is most interesting to do is just continue to take the agenda out and leave the debates to go to deadlock in themselves. And so we have a periodic renewal of new reform propositions that always are abandoned, and on it goes. So I think that's a very interesting example of us to think of maybe how formal rules that are democratic can be influenced by informal power arrangements that will essentially contribute to turning these formal deliberative stances into ways to re-autocratize those that are already problematic in our democracy. So I'll leave it at that.
Thank you. We'll now go to Tinashé, Hofisi.
Right, thank you so much. So I was a human rights lawyer in Zimbabwe when the Constitutional Court of Zimbabwe was established in 2013, and then 3 years later, Zambia also established a constitutional court, and that is what piqued my interest regarding this institution and to answer the question, why exactly were they being established? So what I have done is to trace the legal histories of Zimbabwe, Zambia, and Malawi from the colonial period, from the period there was a single federation for 10 years, and really the critical period for me has been the post-independence era, because some people who follow developments in that part of the world may be familiar with how President Mugabe purged the judiciary, quite famously Chief Justice Anthony Gabe. But what I have found is that in both Zambia and Malawi, there were similar experiences, and these were all emerging from the reality that post-independence judiciaries were predominantly white. So yeah, these independent Black African nations with a very colonized space within the judiciary. And so it almost became predictable that there will be confrontations with the executive. And this has already been written by scholars in the context of what Ogendo called constitutions without constitutionalism. But what I'm focusing on is the fact that the questionable legitimacy of the judiciary, because it was viewed as foreign, it was either foreign judges or white judges, that enabled the political leaders to frame their responses to the judiciary as necessary nationalist responses to this recalcitrant judiciary, which was still steeped within colonialism, essentially. So this theory of governments reacting to judiciaries which take strong court action in the absence of sufficient legitimacy is what I'm looking at is what not only enabled the creation of these strong dictatorships, but what also what enabled mobilization of popular support for purging of the judiciary. And so that happened in the post-independence era. And part of what I'm researching is to extend that also to how these nations also treated the appellate jurisdiction of the Privy Council, but also the fate, particularly of the Southern African Development Community Tribunal, the SADC Tribunal. So there's been writings about when exactly courts claim power, when do they claim power, when do they exercise power, and I am more or less looking at this question of when exactly are courts empowered, when do we give courts the power, that power that they can claim in the future. And I'm saying in the context of Zimbabwe, Zambia, and Malawi, it is then after those judicial purges when these governments are able to appoint local judges. So as the legitimacy within the judiciary is enhanced, then there is greater comfort, there is greater willingness to empower the judiciary, because at the point of independence, these independence political parties were opposed not only to empowering the judiciary, but maintaining them in that state. But as legitimacy increases, then the courts are empowered. So this kind of distinguishes the constitutional courts in Zimbabwe and Zambia from that in South Africa, for instance, where, as I understand it, you introduce a constitutional court almost to bring back or establish legitimacy because you're questioning the apartheid era judiciary. I'm looking at courts which are set up as emblematic of growing legitimacy within the judiciary rather than to establish to establish legitimacy. And then the other interesting questions, of course, would be then, okay, once these courts are established, how are they using this power? Are they claiming this power? And I would say that is the extent to which the theories by Elliott and Von Dijk, when they talk about the other factors such as electoral stability, uncertainty, and how those affect whether courts claim power become relevant. Because these courts have been very important actors within the political within the civic and political space, but in respect of economic, social, and cultural rights, not as much traction as in South Africa, which I think in some ways is explained by Charles Epps' theory, the fact that that part is not as well funded as opposed to the organizations working on civic and political rights, so we don't have the deluge of cases yet for courts to rule in that area. That's stop there.
Thank you. Sofia.
Thank you, Heinz. It's an honor to be here. I'm a PhD candidate at Hofisi São Paulo. I'm also a researcher at the Goldani Research Center at FGV. And my research is about repression to social mobilization in Brazil. So we're going to talk a little bit about what happened during the Bolsonaro government. So despite the fact that there was always really strong social opposition to the Bolsonaro government, we didn't see a great deal of mass protest during those years. There are many factors to that, including COVID, but one important factor that I wanted to highlight here was this really intense process of closure of the space for the dialogue between civil society and the government. And this was signaled in many different ways, including a lot of discursive investments by Bolsonaro and his allies. So a few days right before the election, Bolsonaro gave a public statement saying that he would put an end to all activism in Brazil. After he was elected, when there was a spike in fires in the Amazon region, he was blaming NGOs. In 2019, when the mass protests were happening in Chile, his son, who is a congressman, gave a statement saying that if something like that were to happen in Brazil, they would bring back the Institutional Act number 5, which is a normative from the dictatorship period that allowed the dictatorship to shut down Congress, to implement censorship, to establish a curfew and really centralize power in the executive. And also the government mobilized in some cases, mobilized the national security law, which is also a law from the period of the dictatorship, against some particular opposition actors in order to silence them. And this really indicates an ideological preference for this framing, for this option to frame these opposition actors as traitors, as acts of sedition, because of course, other laws, other framings could have been used. And all of this really had the effect of creating this climate of fear among activists and among social movements. This halted mobilizations before they could even reach the streets sometimes, or before they could pick up strength, and led to a lot of self-censorship by social movements. So this difficulty to access the government and to put pressure on the government, in some cases it led to less street protests and more judicialization. That was the case with the Constitutional Court case on police violence in Rio de Janeiro called a DPF das Favelas. As was mentioned before, police violence is a really serious and important issue in Brazil, and something that predates Bolsonaro. It's something that, for instance, Marta Machado and Raquel Pimenta have characterized as a zone of authoritarianism within Brazilian democracy, where unchecked powers create exceptions to the rule of law. The slums and peripheries of Brazil, which are racialized territories, have been characterized by philosopher Denise Ferreira da Silva as zones of violence outside the domain of justice. And the protests around police killings, they're mostly small and localized. They tend to happen in the territories where the killings occurred, and they are mostly led by the families and friends of the victims. And the state repression to that kind of protest really happens in different ways. It uses a different repressive repertoire, which is in some aspects more violent. One issue that I wanted to highlight in my remaining time is that the framing that is used by police officers to portray, to talk about these protests, it associates the protest events with a criminalizing lens, particularly with the issue of drug trafficking. So actually, the same criminalizing frames that allow for these extrajudicial killings of mostly young Black people that happen on a daily basis, these are the same frames that are mobilized to say that the protests asking for justice for these victims are not actually protests and are crimes, are acts of criminality. One example of this is something that happens after the slaughter in the Jacarezinho slum, where 27 people were killed by the police. The friends and family of these people had put up a memorial in memory of the victims. And this memorial was destroyed by the police. The police of Rio went there just to completely trash the memorial. And they said that they were doing that. They justified it by saying that that memorial was a tribute to drug trafficking. And because it was a tribute to drug trafficking, it was in itself a crime because it was apology to drug trafficking. So this really, it leaves the political motivation of the social mobilization out of the picture. and completely denies the legitimate grievances that are being expressed there, and is in itself a form of repression and a form of historical erasure of popular struggles. Thank you.
So thank you very much for all staying absolutely spot on time, and that gives us time for more questions and engagement from the audience. So it doesn't give us time. We have some time. No. Yeah. So let's have people from the audience. I've got 1, 2, 3, 4, 5. So let's start with that.
Thank you very much, and thank you for your great presentation. It's all interesting topics for research. Looking forward to read them one day. My question goes directly to Jihyeon. You mentioned the Shanghai Coalition, but on counter argument, they have the same argument like the entire international law, especially human rights law. They came from the same perspective, like culture of one part of the world imposed, as they claim, on other part. So they have the right to be free and follow their own culture. Is it like part of your discussion also that you discuss like postmodernism perspective regarding human rights law, international human rights law, or only you are focusing on that Shanghai and maybe new arising coalition in different parts of the world? You are focusing on that. Thank you.
Thank you. Also, for Jihyeon, I wonder if you are studying the different, whether, I mean, this is such an important topic. I agree that, you know, we will have an increasingly, I mean, international law made by authoritarians, but I wonder if you are looking at the patterns. What do they prefer? Do they like co-opt existing structures, or do they bypass them, or do they promote? Because there was this idea, I'm not a specialist in this, I know nothing, but there was this idea that, you know, for instance, China and other countries prefer the Road and Silk Initiative, which is kind of very informal kind of engagement, as opposed to the hard law, you know, multilateral, sophisticated structures. So I wonder if you will be seeing the different patterns there, if this is important or not. What do you think about this? And then about the police problems in Brazil, and linking your different, is there a plan of public interest litigation in this? Because it looks like the majoritarian politics has a block in there. You know, it looks that we are not going anywhere. And I just remember that now the Supremo Tribunal Federal imported it Colombian unconstitutional state of affairs, you know, and that I am sure that the Inter-American Court even, you know, maybe the Supremo and then the court. So it seems to be a space for going to the courts, looking for a more structural, you know, for the courts to trigger a kind of dialogue that could maybe accelerate something in this regard. What do you think?
Thanks so much for a great panel. So just a question on sort of socio-legal theories in sort of periods of autocratization in democratic states. So in Brazil with courts, so there's a great study of Colombia which shows that constitutional court tends to be more activist or expansive in the early sort of phase of a presidential period, and then more deferential as it gets close to election, wanting not to be too visible and become part of the election campaign. But what you described in Brazil is the reverse, where they're very deferential and cautious at first, but then become more active and concerned. And we almost see this with the Trump litigation now in the US. Let's do this now, but we're going to have to control things for the election. So just any reflections on how we think about judicial motivations in democratic versus autocratizing states, and how that influences sort of expansive versus deferential dynamics. And then when it comes to Southern Africa, sort of struck me, your analysis of Charles Epp in the South African case. I agree. And in most standard democracies, most of the investment in strategic litigation is on civil and political rights. Now climate litigation, socioeconomic rights tends not to feature in terms of investment around that. But in states like Zimbabwe, might one expect the opposite, because civil and political rights litigation is highly politicized. There's an argument around development first, socioeconomic rights first. So arguably, the legal opportunity structure is more open to that sort of litigation. It's still political at the end of the day because you're challenging power and elites and different forms of capitalism. But I'm just sort of wondering if you have any reflections on to what extent, say, Charles Epp's theory translates into a Zimbabwean context.
Handball player, I would have got. So thank you so much. This was absolutely fascinating. And I had at least sort of two comments. One is following up on Martin's first point, where I think that there is something about the way in which the state's institutionalized. I mean, some research shows that this sort of reluctance of constitutional courts before elections is a lot more if you don't know who's going to come after, and also the way in which the state behaves. If the president or the government knows that if they're out, they're really out, and they're probably the whole family is out and they're going to be prosecuted, then you're more likely to try and capture it because you don't see it as the insurance going forward. But one of the things that I really was thinking about is that brings the two of you together is the role of social legitimacy for constitutional courts, over courts, and also in a way sort of what government wants to do with courts. Sort of it's when the judiciary has a social legitimacy, that's in a way your argument, that's when you get constitutional court. And so I just want to challenge it a little bit. One is that I think it was not only white judges who have been out in these countries. There have also been black judges, black chief justices, black judges who've been sort of attempted or removed in this process. So I would also say that it's also about sort of the judiciary we want in political terms or not. So it's just a challenge just for you to reflect on, because I think I totally agree, but I think it's super interesting, but I also wanted you to reflect on that sort of the constitutional courts are different because they're not separate courts. They're sort of panels drawn in some cases from the judiciary. So it's a sort of a different way of doing it. And then I think there are many things to say on. I thought it was super interesting. Police sort of dealing with protests and so on. And I think that what you pointed to, Sofia, about sort of the zones of authoritarianism that have been there for a long time are super interesting. So we're talking about autocratization as something that's happening, but it's also sort of really, really different in different parts of society. And in some parts of society, it's been autocratic for a very long time. So I think that is one point that's super interesting. The other is the role of unions, which is interesting because it refers to a small discussion that we had in break. So because unions in theory could be part of the solution, could it if there were reforms, and what would happen for unions to be maybe part of the solution?
Thank you. First question is to Jihyeon. According to your research up to now, particularly with respect to the legal documents, the international covenants between these autocratic states and surrounding debates, the first question is, do you have access to preparatory works, as in the case of UN or as in the case of European Union? That can you just find debates of the parties? Is there a forum like United Nations or European Union? First question is, second question is this. And if you have, or even not, but whatever you have access to, are they silent on human rights, like in the case of non-intervention? Let's focus on our cooperation and nothing else. Or is there an emerging corpus of arguments against the Western side of human rights, particularly as regards to communitarian values of Southeastern Asia or Chinese way of legalism, or authoritarian states for 5,000 years? So is there an emerging corpus of argumentative power. So this is the dangerous part. So the first one is just some couple of rogues that are coming together to beat us. But the second one is they try to build the hegemony, the discursive hegemony. Is there anything like that? So to Bianca is, you talked about the timidity of the Brazilian Constitutional Court. To what extent are they timid, or to what extent are they proactive in supporting the authoritarian regimes? This intersects with the question that I asked, whether they are neutral or are they proactively authoritarian? And also to Tinashé, sorry, I mispronounced your name. And also to you, to what extent the judges use anti-colonial discourse in not supporting the human rights, or are they supporting the human rights, the current, as regards to your jurisprudence, as regards to the research you made on the jurisprudence of the countries that you mentioned? Is there a way of judges' articulation of non-supporting the human rights as a way of legitimizing their discourse in their jurisprudence?
One more urgent question back there.
But you raised your hand very quickly. Thank you. Thank you. This was amazing. Just one question to Jihyeon. I was really intrigued by your reflection. Thank you. It was very important issue. Just how would you think through the lens of autocracy and democracy when in international law the distribution of powers happens in a reverse way? So you mentioned, for instance, the principle of sovereignty as a way by which autocrats can hold on to national law. But when we see in international economic law is that something at the inverse happens. So you have countries being accused of expropriating just to protect environmental resources and then being held up to international tribunals, right? So that functions the other way around. What are your reflections on that? And just to Tinashé, thank you very much. We have been talking about Fanon's work here throughout the exchanges. So how the microdynamics on racism, how people perceive themselves just after a post-colonial state play out in judges' construction of self-legitimacy, you know, and how that plays out in the construction of a broader legitimacy of courts. Thank you.
A great panel. Thank you for your insights. My question is to Sofia. I saw very similar patterns of discursive criminalization of activism in India with the Brazilian case. For example, the Prime Minister used the metaphor of pests or parasites feeding off activism to delegitimize any kind of social movement. So I was wondering, did you observe, now there was a silver lining in India that the farm laws, the unfair farm laws were rolled back by the government after massive and sustained protests. So there was some kind of a positive effect it had on autocratization, so to speak. So in Brazil, did you see any real or tangible effects? I understand the repression bit, but did it also have a positive effect on pushing back against Bolsonaro? Okay, shall I go back?
That's fine. Great. And I would just add, I will abuse my position. I'll abuse my position to ask two questions. One is, what's interesting in the international context is, of course, during the whole long period of that struggle against apartheid, the South African state constantly argued this was an internal affair under 2.7 of the Charter. And so one wonders how this has been played out. So the human rights struggle was always opening that up. And so how does that play? And Tinashé, you know, you also talk about the fact that the courts are now dealing with electoral matters, right? You see these courts actually strike down presidential elections. What does that do for courts when they're actually at that point? So they're not stepping back before an election. They are deciding the election, right? What does that mean? But so you've got 3 minutes each, and shall we just go in reverse order this way? Sofia.
Sure. Thank you so much for all the questions. They were really great. Starting with the issue of public interest litigation on police violence. So there were some attempts. There was one main attempt specifically in the context of police operations in Rio de Janeiro, where it's a really big issue, which was the Slum Act, the PEC das Favelas. It was only partially implemented. It required some restrictions on police operations, on the use of helicopters with weapons, on a series of things that are common. And it was partially implemented. Some very important things, such as a target of reducing police lethality by 70%, was not implemented because it was deemed unfeasible. So there's that. But there were some gains, which also answers a little bit Shu's question. There was a reduction in the number of police operations for a period that is calculated to have saved a few hundred lives, because these police operations very often result in deaths, even when they're not mass slaughters. But there is an issue, which is when we look at the Jacarezinho slaughter, I think it's important to note it happened during the pandemic, at a period where there was a ruling by the Supreme Court that prohibited police operations in favelas, except in very exceptional circumstances that had to be previously authorized. That was not the case. This was a slaughter, an operation that happened in revenge because a police officer had been killed a few days before, and this is a very common trend with these slaughters. So it was in blatant disrespect to a Supreme Court decision, and this has something to do, and this is my main point, this has something to do with this growing process of autonomization of the police in regard to the government and to the STF, to the Supreme Court. So I'd say that is the main challenge, that the police has been gaining strength as a political actor. And then during the Bolsonaro regime, because you had this pro-police killing discourse at the federal level, and this guy who was always very much in favor of police corporative interests, even, that really just gained strength. But there is one other public litigation that still hasn't, that has been presented, but still hasn't developed very much, but it is the ADPF das Vidas Negras, so the Black Lives case, and that's like a really comprehensive case. It's not just about police violence and police killings, but about racial discrimination in Brazil in like a very broad sense, and the kind of measures that it asks for are really comprehensive in terms of education, of feeding, of many things. So it would be interesting to see how the Supreme Court will react to that, especially now after this one. And just very quickly, because I have 10 seconds, it's just to say, like, there were no mass demonstrations as we had in the previous years, but there were smaller demonstrations. There were particularly important demonstrations on the COVID mismanagement, and that was really important. Like that had an impact of an important contention to Bolsonaro. They were just not like as big, but they were significant.
Thank you, Sofia.
Yeah, well, just some maybe additional comments on public interest litigation against police violence. I think it's definitely it's on the rise. So I think that makes a really interesting research agenda. Besides those cases that Sofia mentioned, I think, so that was at the federal Supreme Court, that's the STF, but we've also had interesting cases on racial profiling, police stop and frisks, and other matters. These are like smaller, less public cases. They're judged at the Supreme Court of Justice, which is a different thing. We have a weird system. There's a lot of courts, but it's also a apex court, but that only does national legislations, not constitution. And so it's definitely on the rise. And I think me, Sofia, also Marta, who isn't here this year, are very interested in this. Me particularly, because I really believed it needed to be a political solution. That's why I wanted to look at bills. And because of the things Sofia mentioned, so I think with the police that we have in Brazil, court decisions and their implementation can be a challenge. And then I always wanted to look at the politics of it. But when you read the literature from political science, what all of them are saying is that because of the public opinion being so tolerant with police violence, that just means there is a really, really hard, that it's really, really hard to create incentives for political actors to get involved when you consider the counterweight of these police associations and just the risk of the threats they can make. And then just very quickly on Siri's comment on police unions, yes, you totally got why I was so interested in that panel. I'd like to just highlight that these professional police associations, they're officially not unions, they're clubs, leisure clubs. And then I have thought about it, like if we had, especially on that discussion, if we had a union that made it possible to have organic representation, Because some low-rank police officers that I talked to in Greenfield, where they did tell me, no, but the people who run these lobbies, they don't care about the working class policemen. They're doing their own thing, and they don't care if we get paid breadcrumbs. But I think it's complicated. I mean, could we guarantee that a police union would represent those guys? Or would it give more power and more legit? I mean, if they are doing this with these weird lobbying associations that are not even really supposed to exist, what would it mean to have official police unions? It could just, I think an argument could be made that what we need to do is lessen the political power of these corporations, and then maybe we can negotiate. I think they need good working conditions, but I don't know if that's the way to do it. I think it could get better or get worse. And so I'll just leave it at that.
Thank you. Tinashé.
Okay, so thank you, Siri. Now, Malawi does have the Constitutional Court with panels ad hoc at the High Court level, but Zimbabwe and Zambia, those are standalone constitutional courts, and that's so Malawi in some ways is a comparator. It wasn't just white judges, it's true, that were targeted, but the governments always frame it as anti-colonial when it involves the white judges. With the black judges, it's always tied to some offense, which I then compare with Ghana when it's at the Chief Justice level, the response to the Chief Justice being targeted that way for an offense, as opposed to the white judges, the response is different in a lot of ways, the way in which the judiciary refused to even recognize the next Chief Justice, unlike in my comparator countries. I certainly agree, Malcolm, that the economic, social, and cultural space would, I say courts are more open to it, but civil society, we just don't have that sort of support. Now, if you look on the civil and political rights side, it's like a cottage industry in Zimbabwe. There's so many of them because the donors simply respond to that. And so that is what ends up in the courts. There's just not so much response on the economic, social, and cultural rights side of things. Regarding anti-colonial language, I have noted some of it, but mostly it is to do with cases to do with land and the court's refusal to slap down the land reform program by embracing the narrative that there is this history of dispossession which must be corrected. That is the extent to which I've seen it. And then sometimes in electoral petitions, like in presidential elections, when the opposition will argue that rural voters are only voting because they've been given trinkets and gifts, and the court says, well, no. In the colonial era, there was this refusal to recognize agency of people because they were rural, and you find some of that, but I haven't found it in sort of a rejection to enforce human rights. And in the interesting point about presidential petitions, that's also very interesting and also context specific to the extent that Siri has pointed out the dynamics of whether there's an anticipation of a change of government and how that influences the extent to which a court will be active. But generally speaking, I would say structurally, we've got these presidential petitions coming in these top courts, but it's all concrete review, no abstract review. So overall, all the decisions are going to cause such discontent that it kind of also threatens judicial legitimacy. And then Talia's question, I think we'll have to discuss that. Thank you.
Thank you.
Yeah, I'm very slow, so I might have to chew on all these great points for a while, but I think it might help to draw a better picture on your mind, like what it looks like, right? What is this a group of dictators, gathering together? It's not like a group of like Disney villains trying to diffuse all these malicious ideologies to countries abroad. It's a group of state leaders who want to cooperate, and it's very tempting to like confine our image of all these authoritarian international law to dictators in Asia and Africa trying to do something bad. But it's not quite like that. If you look at the very face value of it, a lot of these institutional structures are very much alike what we have from liberal democracies. So, to address some of the points and questions, they're not trying to diffuse unique ideology they have, but they're just trying to pick up the dialogue and this debate between human rights versus sovereignty, bringing the toolkit of a treaty. And, my question is looking at, would that make any difference? And if so, why? And if not, why not? So I hope that kind of drew a better picture of what I try to, analyze and what are the phenomena that I'm interested in. And in a similar vein, they have a lot of well-institutionalized and legalized structures, and there are a lot of resources that keep track of the dialogues and debates from a lot of dispute settlement mechanisms. So you'll be able to look at all these legal documents and what are some of the debates that these countries are addressing.
I hope that answers some of the questions. I'm happy to chat more about it afterwards.
Thank you. Yeah.
Okay, real quick. I'll just pick up on Gurkan's question, because I'll start saying that STF was never timid, at least not since 2006, which was when the biggest case of corruption till now came up in Brazil. STF, when Dilma was the former president, it revoked a nomination she had made because she nominated Lula as her minister, and one single justice of STF revoked that nomination. So STF was not on that classical position that constitutional courts, when they are analyzed by being disposition of attacks by authoritarian leaders. STF is a very strong institution in Brazil and was never really in danger. Even though the court was attacked, and the court itself has better indexes of legitimacy compared to the other political institutions in Brazil. But what happened is, and this brings up what Siri commented on, that is the justices made a choice to have close relationship with an autocrat that had already said many times that it would be okay to shut down a Supreme Court, a constitutional court. It was Bolsonaro's son that said that, and a few months later, his Minister of Economy echoed the same position about Institutional Act number 5. And while this was happening, the trials were taken to court and the justices were not acting, at least not until 2020. So there's a question here concerning judicial independence and social legitimacy, and also how to frame that in terms of, analysis, because we need to point out what they could have made and they decided not to. And of course, we need to highlight also that in terms of undermining democracy, like Siri also highlighted, STF was responsible for taking Lula out of the electoral competition, and that enabled Bolsonaro to rise. So this is a really strong institution, and they had made a great work. And we hope we have the best news in the next few days, because probably Bolsonaro is being arrested, and we hope so. But it's this, they could have made so much more, and they chose not to until they were in a favorable position. So that is it.
That raises an interesting question. Do you need his arrest, or do you need the fact that what you've already done is saying he can't participate in politics for a period of time? I think
more out of the
no, I know, but it's interesting, right? In the US, it might be better if they would say that Trump is out of the process than that they're trying to arrest him.
Don't yes, and don't get us wrong. Taking Bolsonaro out of the competition, it won't solve Brazil's problems. He has a whole gang, and yes, but he needs responsabilization. So yes,
I
So
think,
responsibility method.
yes.
honestly, I think that the best sign was that they didn't really try to, with the decision that he was out of the run, there wasn't a huge backlash mobilization. And I think that for me was an amazing sign, because with Lula from the start, he was able to mobilize people to say that this was an unfair trial, that this was political persecution. And I think with Bolsonaro, some people rose up, and like a lot of his social media army or whatever, his sons, but it wasn't able to get much traction. And then I think they feel that this is a no wins for him. Like they're not going to be able to narrate it in a good way. Also, they don't have a new leader to take up his project for now. I mean, we've seen in Argentina that can happen quickly, but I think for now, this has been a good thing in the sense that it demobilized the people. His base supporters are a bit lost, and that's great.
Well, on that note, thank you very much. Please join me.
Thank you. Thank you so much. I'll bring cups. But I also want to say that this was admirable. You all were able to sort of stick to time in both rounds. and say so much interesting. So I think there's a lot to learn. Wonderful on many levels. We will have lunch. There will be a documentary screening here at the 1:45.